It seems some of you are asking who's keeping track of the appellate issues. My guess is Andrea Burkhart's all over it like white on rice, but she also has a day job. So rather than relying on her entirely, I decided to give it a shot to try and list some of the appellate issues according to weight. Disclaimer, I'm not a lawyer. I had to do quite a bit of research to get this into some sort of weight order, and it may be incorrect, and I dare say we are nowhere near finished yet. So this is going to be a work in progress, and this is just part one of trying to organise it all. And if we're lucky, one of the law tubers out there who does have experience with appellate law might offer to talk with us about how to rearrange everything into a better order. So let's go. Appellate issues for Massachusetts versus Karen Reed 2025. As I just said, these will be ordered by weight, which is the strongest arguments first. And of course, any time there is judicial corruption involved, those are obviously going to be the strongest arguments. But even judicial corruption has its own weights. For example, obstruction of justice is a much stronger issue than just bias or abuse of judicial power. Bias might raise red flags, but obstruction invalidates the entire legal process. Auntie Bev's obstruction crosses into constitutional violations, due process, confrontation, press freedom, etc. Likewise, these would take priority over prosecutorial obstruction or prosecutorial misconduct. And so this is how I've weighted them in some kind of order. We'll get into the details of each in a moment, but next in order of weight is suppression of federal oversight and habeas violations, which have far more weight than egregious prosecutorial misconduct, even though it is egregious. In my guesstimation, these would be the 5 top contenders for post-trial appeals. But of course, we know there's more than that. We know there's improper sanctions and Rule 14 abuses by Auntie Bev. In my guesstimation, there would be compounding issues, just as misuse of evidence by the prosecution and expert suppression by both Auntie Bev and the prosecution might be. And of course we have the timeline manipulation, the jury misinformation by Adam Lally in the last trial. And finally, the emotional manipulation by exploiting John's niece and nephew. So let's deconstruct each of these categories and see if I've forgotten anything. First cab off the rank is judicial obstruction of justice. First, I'm going to describe what that is and give a brief summary how the appeals court looks at those things. And then I will give some examples in the Reed case specifically. And then I'll provide some of the case law that might be applicable at appeals. Judges are the gatekeepers of fairness. A judge's role is to ensure both sides receive a fair trial. When a judge actively or passively allows misconduct or participates in it, the entire legal process is compromised. Appellate courts are more inclined to act when the neutral arbiter, the judge, has violated neutrality. Prosecutorial misconduct can be cured. Although it is serious, courts sometimes find it harmless if the judge issued proper jury instructions, the defence had opportunity to cross-examine, or the misconduct didn't affect the outcome. Judicial misconduct usually can't be cured. If the judge themselves is compromised, biased, or obstructing defence rights, appellate courts view this as a structural defect. No jury instruction or cross-examination can undo the damage if the trial referee is unfair. Specific examples in Karen Reed's case would include Canoni denying exculpatory evidence, for example the Sallyport CCTV, chain of custody records, etc., appointing herself as a permanent judge despite rotation, failing to delay trial pending habeas proceedings, and using her administrative role to control courtroom access and jury operations. Auntie Bev's obstruction through denial of motions, selective enforcement of rules, suppression of federal involvement, and retaliation against the defence, carries greater appellate weight than the prosecution's misconduct if well documented. Some of these federal law citations we are well familiar with, since we've covered them in previous videos. Remmer v. United States, 1954, provides juror contact by outsiders is reversible if the judge fails to protect impartiality. Caperton v. A.T. Massey Cole, 2009, even the appearance of judicial bias violates due process. And of course, Brady v. Maryland. While Brady violations often involve the prosecution, failure by the judge to compel evidence production amplifies the breach. Category 2. Judicial bias and administrative abuse. Judicial bias is a structural constitutional violation, often reversible per se. When a judge demonstrates actual bias, or even the appearance of bias, appellate courts often treat it as a structural defect in the trial, meaning it affects the very framework of the proceeding. This is based on a key principle: a fair trial requires a neutral arbiter. And if the judge is not neutral, everything else collapses, regardless of how strong the prosecution's evidence may be. Judicial bias doesn't just taint individual rulings, it undermines the legitimacy of the entire proceeding, and this is why appellate courts often don't apply the harmless error test to proven judicial bias. It's considered fundamental error under both due process, 5th and 14th Amendments, and the 6th Amendment, fair trial guarantees. Bias is evaluated from the objective viewpoint of a reasonable observer, not just what the judge claims. Actual examples in the Karen Read trial: appointing herself as a permanent judge despite rotation and requests for recusal, administrative decisions affecting juror access and security, consistently ruling in favour of the prosecution even when evidence was constitutionally contested, refusal to allow mention of federal subpoenas and misconduct investigations, personal involvement in jury foreperson selection and notebook access, attempts to intimidate the defence with Rule 14 sanctions and public rebukes, disproportionate enforcement of media gag orders, and a permissive atmosphere towards hostile witness behaviour and outside influence, particularly by individuals close to law enforcement or the prosecution team, i.e. Proctor's family. The case law that might support these arguments: Toomey v. Ohio, 1927. A judge with even a financial or political interest in the outcome violates due process. Caperton v. A.T. Massey Cole, 2009. Even the appearance of bias due to outside relationships or influence warrants recusal. Williams v. Pennsylvania, 2016. A judge who previously had a role in prosecuting the case cannot later preside over it. That's in relation to her recusal motion. In Re Murchison, 1955, no man can be a judge in his own case. Applies to judges whose conduct or prior decisions show partiality. Judicial obstruction and judicial bias are two of the strongest appeal grounds. They supersede most prosecutorial misconduct unless the prosecutor's actions also amount to a structural constitutional violation, i.e. vindictive prosecution or fabrication of evidence. Active interference in the judicial process designed to suppress, delay, or mislead justice, often involving external manipulation, is a serious constitutional violation when it violates a constitutional right, impairs due process, taints the fact-finding process, or retaliates against the defence, and any of these things can trigger reversal, dismissal, or habeas relief, especially if systemic or retaliatory in nature. Specific examples in Reed's case includes falsifying or selectively presenting text stream and BAC evidence, attempting to seize defence communications through Rule 17 in another defendant's case, i.e. Aidan Carney, retaliatory witness naming of Reed's legal team, blocking federal disclosures while simultaneously accusing the defence of collusion with the federal prosecutors, suppressing the medical examiner and trooper proctor, who's no longer a trooper, from testifying in Trial 2.0 to hide contradictory findings, filing emergency hearings without defence notice to gain tactical advantages, and refusing to turn over full witness info under the guise of intimidation risk. These standards are all assessed under Brady v. Maryland, United States v. Aguirre, Bank of Nova Scotia v. United States. They could also be assessed under Berger v. United States, Darden v. Wainwright, United States v. Young, and all of these examples would be first assessed under the harmless error test, in which case they could be curable by jury instruction, unless they are combined with judicial bias and or obstruction, and in this case they are. Category 4. Suppression of federal oversight and habeas violations. Appellate courts typically approach suppression of federal oversight and habeas violations, including the assessment of these issues, in the context of constitutional protections and precedent. Auntie Bev's failure to stay proceedings during a pending habeas petition appeal raises legal concerns, because continuing with a state trial may interfere with federal jurisdiction and violate the Supremacy Clause. Additionally, punishing a defendant for complying with a federal subpoena, especially when compelled, infringes on the right to petition the government under the First Amendment and may amount to vindictive prosecution. Blocking the jury from learning about federal oversight raises more legal concerns. Preventing the jury from hearing that evidence originated from federal oversight may distort the weight and credibility of that evidence and deprive the defence of fair presentation of their case. And let's not forget that state actors are representing federal adversaries in the higher courts. When state-level actors, i.e. Morrissey's office, are appointed to represent judicial interests in a federal habeas proceeding, it creates a conflict of interest and undermines independence of the habeas process. Not to mention the Supremacy Clause. When Attorney General Andrea Campbell appointed D.A. Morrissey's office, the prosecution in this case, to represent Judge Cannone in the federal habeas proceeding, it created an outright conflict of interest, even as Morrissey is under scrutiny for collusion with trial witnesses. The appellate weight given to these issues rank highly because they are related to constitutional violations, 1st, 5th, 6th, and 14th Amendments. They represent interference with the federal processes, and they represent potential structural error, which doesn't necessarily require proof of prejudice to reverse. I think what's lost on a lot of people is that Karen can, at this point right now, before Trial 2.0 even starts, request federal oversight. This is a process that comes out of the DOJ, who would then appoint none other than the United States Attorney's Office for the District of Massachusetts, the very office that Morrissey is trying to accuse the defense of colluding with. The very federal authorities who are responsible for overseeing the DA's office. Put simply, Morrissey thinks he's above the checks and balances put in place to keep him below the federal authorities. He's literally trying to hijack Karen's legitimate right to request federal oversight of Auntie Bev and his office. Category 5. Egregious prosecutorial misconduct. As you all know, this can be summarised by reading both motions to dismiss prior to Trial 1.0 and Trial 2.0, but essentially, appellate courts do take prosecutorial misconduct seriously. How they respond depends heavily on two key factors. 1. Whether the misconduct violated a constitutional right, like suppressing exculpatory evidence, improper comments on the defendant's silence, targeting the defence with retaliatory charges or tactics, introducing knowingly false testimony. And 2. Whether the misconduct was harmless or prejudicial. Where most prosecutorial misconduct appeals fail, courts apply the harmless error doctrine. If the appellate court believes the verdict would have been the same without the misconduct, it will not overturn the conviction. Even serious misconduct may be excused if the judge gave curative jury instructions. However, this all changes when there is judicial obstruction of justice and judicial bias involved. Some of the examples in Karen Reid's case includes inflammatory opening and closing arguments, i.e. changing the 12:45 timeline and misleading the jury, misstatements about the text stream or taillight data during testimony, attacking the defence in front of the jury or accusing them of conspiracy, mischaracterizing chain of custody and presenting it as intact, arguing consciousness of guilt based on media interviews or protests, and misleading portrayal of witnesses, i.e. Colin Albert's involvement. These are classic courtroom misconduct patterns, and while egregious, they're often curable by jury instruction, unless combined with judicial bias or obstruction. These all fall under case law that we are all well familiar with by now. Brady v. Maryland says suppression of exculpatory evidence violates due process. Nepew v. Illinois, 1959, knowingly using false testimony violates the 14th Amendment. And Berger v. United States, 1935, prosecutors must seek justice, not just convictions. Their interest is not that it shall win a case, but that justice shall be done. Now we'll move on to lower weight but compounding issues. This includes Category 6, improper sanctions, and Rule 14 abuse. This will include harassment by sanction, repeatedly subjecting defence expert witnesses to voir dire as a form of penalty, especially where the basis for challenge has been previously addressed, may constitute due process violations and judicial harassment, particularly when paired with sanctions. And sanctions without bad faith or prejudice amount to Rule 14 abuse. Massachusetts Rule of Criminal Procedure 14 governs discovery, but sanctions for non-compliance must be proportional, based on willful misconduct or prejudice, and balanced against the right to a fair trial. So the examples that relate to this section in Reid's trial include when the defence was subpoenaed by the feds but were unable to produce discovery. Remember, Auntie Bev sanctioned them for that. She also publicly ridiculed them in front of the pool cameras for it, despite knowing it's out of their control. Now Bev's saying ARCA experts are subject to a second voir dire, after she already sanctioned defence under Rule 14 and then allowed their testimony before. No new foundational issue justified this action. It simply reframed as another Rule 14 sanction. The fact that the defence have complied with their Rule 14 obligations, to the extent that they could comply with them at the time, yet they've now been sanctioned multiple times for the same Rule 14 violation. This compounds pressure on defence finances and expert credibility. The case law that supports these arguments is Ake v. Oklahoma, 1985. The defence has a right to meaningful expert assistance, and the state cannot create undue barriers to expert testimony. United States v. Marino, 1991. Courts must avoid creating chilling effects that dissuade defence experts from testifying. People v. Batista, 2007. Repeated voir dire of a previously qualified expert can amount to judicial overreach if not supported by new material facts. Commonwealth versus Durham, 2006. Dismissal of evidence or restriction of witnesses is a remedy of last resort, and the court must consider lesser alternatives first. This is also why Richard Allen won an appeal and got his attorneys back, because the appeals court ruled that that was a remedy of last resort, and the judge had other options. And lastly, Taylor versus Illinois, 1988. Sanctions that deprive a defendant of the ability to present a key witness implicates Sixth Amendment confrontation rights. For some reason that one didn't make it on the slide, but oh well. Moving right along. Number 7. Misuse of evidence and expert suppression. The introduction of forensically unreliable or incomplete evidence raises legal concerns. When prosecutors admit flawed or misleading forensic evidence, for example, serum BAC instead of whole blood, altered CCTV footage, etc., courts scrutinise whether this constitutes a violation of due process and whether it materially affected the verdict. Suppression or intimidation of defence experts also raises legal concerns. Appellate courts have consistently ruled that exclusion or unreasonable limitation of expert witnesses on the defence side violates the right to a fair trial, especially when those experts are targeted or harassed. This may create grounds for reversal. And finally, court-sanctioned narrative framing also raises legal concerns. When the court restricts the defence from presenting evidence contextually, not being able to reveal the federal source of evidence, it infringes on Sixth Amendment confrontation rights and 14th Amendment due process. There may be a little redundancy here, because some of the examples in the Karen Reid trial apply to multiple different categories. So here we're talking about the serum BAC results that were introduced without conversion to whole blood despite known inflation. Prosecutors introduced tampered taillight evidence and altered the red channel data. Blood collection in solo cups and proximity to the taillight component created cross-contamination risks, undermining the alleged DNA discovery. Arca and Dr. Russell were targeted by Rule 14 and revoir dire despite no new evidentiary issue arising. This one hasn't happened yet, but I'm sure it will, where the FBI analyst would be barred for testifying as federal agent, requiring the defense to present their evidence stripped of credibility and rebranded as insurance experts, and whatnot. Discovery delays and financial pressure tactics serve to discourage expert involvement or thorough analysis. Court barred mention that expert findings originated with the FBI and came via TUI subpoenas. The jury believed experts were hired by the defence, affecting their perceived neutrality. And it all resulted in a skewed view of the facts, especially since prosecution was allowed to assert its state forensic narrative without challenge. These fall under case law. Nephew versus Illinois, 1959. The state may not use false or misleading forensic evidence, even if unintentionally presented. Giglio versus United States, 1972. The government must correct false testimony once it becomes aware of it. Dalbert versus Merrill Dow Pharmaceuticals. Expert testimony must be both reliable and relevant. Commonwealth versus Patterson, 2005. Forensic evidence that lacks a chain of custody or introduces risk of contamination may be excluded. Appellate courts look for judicial abuse of discretion if it's not. Chambers versus Mississippi, 1973. A defendant has a right to present a complete defense, including access to expert witnesses. Washington versus Texas, 1967. States cannot arbitrarily limit the admissibility of defense testimony. United States versus Sheffer, 1998. Courts may not categorically exclude defense experts without case-specific justification. Commonwealth versus Priscilla, 2015. Massachusetts Supreme Judicial Court held that barriers to expert testimony must be minimal unless there's compelling prejudice. Holmes v. Carolina, 2006. Courts cannot bar relevant defense evidence based on arbitrary assumptions of reliability. Crane v. Kentucky, 1986. Defense must be allowed to contextualize its case. Limiting their narrative is unconstitutional. Category 8. Timeline manipulation and jury misinformation. Prosecutorial narrative shift mid-trial in Trial 1.0 created legal concerns because when a prosecutor presents one timeline in opening statements and alters it during closing, especially without evidentiary correction or judicial instruction, it can constitute misleading the jury, a potential due process violation. Auntie Bev's failure to correct factual contradictions is also a legal concern. A judge has a duty to instruct the jury appropriately and ensure that the trial is not misled by contradictions or confusion in the prosecution's narrative. And thirdly, material effect on jury deliberations is also a legal concern, because timeline inconsistencies that relate to opportunity, intent, or alibi are considered material. If the jury relies on misinformation or is deprived of critical context, the verdict is potentially compromised. And the examples in Karen Reed's case, as you may remember, ADA Lally presented a timeline in opening statements placing the alleged crash at 12:45 a.m. By closing arguments, he'd changed it because Trooper Guarino's testimony revealed Reed connected to O'Keefe's Wi-Fi at 12:36 a.m., proving she was in the house at that time. Lally altered the timeline in his closing arguments without explanation, and the jury was never informed of the contradiction. Judge Canoni took no action to reconcile or clarify the timeline for jurors. Jurors were reportedly unaware of the timeline contradiction and assumed Lally's closing narrative to be uncontested fact. But it's okay, everybody, because Auntie Bev's instruction to the jury wasn't about reconciling or clarifying Lally's timeline, it was just having a go at the defense again. The judicial failure to issue corrective instruction allowed the state to manipulate the narrative arc without challenge. Prosecution's initial timeline was key to the theory of intent. The change mid-trial conflicted with defense positioning and obscured possible third-party involvement. Jury deliberations proceeded without proper context, leading to flawed conclusions, including the widely reported juror rationale, Reed and O'Keefe were both there and only one of them is dead. The case law that would support all of these arguments would be Berger v. United States, 1935. Prosecutors are held to a higher standard of fairness and cannot misstate evidence or shift theory without explanation. Commonwealth v. Johnson, 2012. The court condemned shifting theories of guilt without notifying defense or correcting the record. United States v. McKeon, 1984. Inconsistent prosecutorial narratives cannot both be true. They raise questions about the integrity of the state's case. Taylor v. Kentucky, 1978. Jury instructions must compensate for prejudice or confusion, particularly in high-profile cases. United States v. Kajayan, 1993. The court must intervene when a misleading impression of a key fact is left uncorrected. Commonwealth v. Jakiri, 1992. When newly surfaced evidence contradicts prosecution's timeline or theory, the court must address it. Nipu v. Illinois, 1959. Even a single misleading fact, if material, may require reversal. Kiles v. Whitley, 1995. Materiality is not just whether the evidence would result in acquittal, but whether it undermines confidence in the verdict. And once more with Commonwealth v. Jakiri, 1992, emphasises the integrity of the verdict over harmless error defences. Category 9. Child exploitation and emotional manipulation. How do appellate courts view this practice? Interestingly, improper emotional appeals are reversible if prejudicial. Appellate courts consistently disapprove of overly emotional, prejudicial testimony introduced solely to inflame the passions of the jury, especially if it lacks clear evidentiary weight on the central question of guilt. I wonder if the same could be said for Ali and Jen McCabe crying about witness intimidation from protesters. Children's testimony must be carefully scrutinised. Courts recognise that minor witnesses, particularly those related to a victim, require special judicial care. The statements must be shown to be voluntarily made, based on personal contemporaneous knowledge, and not influenced by adult suggestion, trauma, or leading questions, none of which Lally was humanly capable of. Courts discourage manipulative use of family members. In multiple rulings, appellate courts have reversed convictions or warned prosecutors against using a decedent's close family members, particularly children, when their testimony is designed to elicit sympathy rather than truth. Jury instructions are often insufficient. Even when a judge gives jury instructions to disregard emotional elements or only consider facts, appellate courts recognise that emotional testimony by minors, especially in the context of a violent death involving a family member, may irreparably bias a jury. The red flags in the Karen Reid case were the children were niece and nephew of the victim, not eyewitnesses of the events of January 29th. Their testimony focused on past domestic friction unrelated to the crime. There was no corroborating physical or testimonial evidence supporting their claims. I would add also that it was hearsay. The testimony was introduced mid-trial at a critical point, seemingly to reinvigorate emotional engagement. The prosecution did not properly lay foundation for reliability or absence of adult coaching. The grounds for appeal here would be violation of due process under the 14th Amendment, trial fairness compromised by emotionally manipulative, irrelevant testimony, failure to exclude prejudicial evidence under Daubert-Lanigan, judicial error for allowing the testimony without rigorous evidentiary foundation or in-camera review, and pattern evidence of prosecutorial overreach and improper narrative tactics. The case law that would support these types of arguments includes United States versus Hitt, 2006. A conviction was reversed because the prosecution used emotionally evocative evidence that was only marginally relevant and served primarily to paint the defendant in a bad light. Well, that's completely nothing like the Karen Reid case, is it? Idaho versus Wright, 1990. The Supreme Court ruled that child testimony must be reliable and supported by particularized guarantees of trustworthiness, especially when used in emotionally charged prosecutions. People versus Jackson, 2002. The California Supreme Court emphasized that prosecutors must not encourage emotional appeals to jurors' sympathy or prejudice by offering irrelevant, emotionally loaded family testimony. And lastly, Davis versus State, 2014, emotional child testimony without clear relevance was deemed to override curative instructions, warranting reversal. So, those are the main categories I came up with. Just to recap, the top 5 by weight were 1. Judicial obstruction of justice, 2. Judicial bias and administrative abuse, 3. Prosecutorial obstruction of justice, 4. Suppression of federal oversight and habeas violations, and 5. Egregious prosecutorial misconduct. The remaining 4 categories I classified as compounding issues. That is 6. Improper sanctions and Rule 14 abuse. 7. Misuse of evidence and expert suppression. 8. Timeline manipulation and jury misinformation. And 9. Child exploitation and emotional manipulation. And if it turns out we need more, then I've got a spare box for that as well. I'm going to keep working on it and developing the structure and the categories. I still need to add a lot of stuff that happened in trial 1.0 that I don't have in this one yet. I also need some advice from an appellate lawyer. That would be awesome. And who knows, if that happens, we might end up with a completely different structure. So you can expect more videos on this while I keep an eye on all of the appellate issues. And I'm probably going to hazard a guess that Bev is not done yet. I expect every hearing from here on in to start with a new appellate issue.